Well, hello, everybody. Hello and welcome to our Constitution Day talk. I appreciate you all being here. This is the first time I've done something of this sort since the pandemic started, so it's exciting to be back, not just in the classroom, but to be joined by two of my esteemed colleagues at Catholic University to talk about Constitution and Constitution Day. For those of you who don't know me, my name is Matthew Green. I am the chair of the politics department, currently located here in this building on the fourth floor. I study American politics with a focus on American political institutions. I'm joined here today by two other faculty at Catholic University. To my far right, Sarah Duggin. Duggin. I had it right the first time. Sorry, Sarah. An expert on constitutional law and corporate law, and the author of numerous law review articles. And Stephen West, associate professor of history, is an expert on Southern history and the author of From Yeoman to Redneck in the South Carolina Upcountry, 1850 to 1915. So we're each going to talk about this theme of why the Constitution still matters from different perspectives. We'll start with Sarah on my far right, then Steve, and then myself. We'll each talk for about 10 minutes, and then we'll have the remaining half hour open for time for you to ask us any questions you have.
Thank you, Matt. It's a pleasure to be here, and I'm so glad that you're here today to talk about the Constitution. If you can't hear us in the back, just wait, okay? I thought that it might be fun to start with a few facts about the Constitution. So does anybody know how many articles or principal provisions there are in the Constitution? Just call it out. Yeah.
6.
You're very close. It's 7, very close. And amendments, we've got 27 amendments. And we often talk about it takes a while to get things done. Anybody have any idea what the longest time period was between proposing an amendment to the Constitution and ratifying it? Just guess, anybody?
8 years.
8 years would be long.
About 200 years.
You're very close. It was 203 years. The 27th Amendment, which deals with congressional compensation, was proposed by a 2/3 vote of the House pursuant to Article 5, which talks about amendments in 1789, and it wasn't ratified until May of 1992. So what about the length of the Constitution? It's actually relatively short. It's only in the 1787 Constitution, or the basic Constitution, is only about 4,500 words, and that includes signatures. And with all the amendments, it's still only about 7,500 words. That's about as long as 2 to 3 significant news articles in the New York Times or the Washington Post, and it's shorter than a number of the president's State of the Union addresses. The First Amendment has only about 45 words, yet it's one of the most important guarantees of freedom of all time. But while stats are fun, it's content that really matters. So anybody know or can tell me anything that the First Amendment protects? What are the freedoms it protects? Just call them out.
Freedom of speech.
Speech. Religion. Press.
Petition and assembly.
Awesome. Well done. All right. And then we infer, not from the language itself, but we infer a 6th freedom, which is association. The Constitution, as we know, is one of the greatest documents of world history because of all of its protections. But I hope we also know that the 1787 Constitution and the Bill of Rights had a terrible flaw. The Constitution itself never mentioned the word slavery, but for 80 years, it failed to define all people as citizens, and even worse, it safeguarded property rights in human beings until the ratification of the 13th, 14th, and 15th Amendment between 1865 and 1870. And during that time, many Americans were not free in any way, shape, or form. For those of us who are women here, we didn't gain the right to vote until 1920 with the 19th Amendment. And we still have a long way to go to realize our dreams of equality, liberty, and justice for all, particularly for people of color. So as we go forward, we struggle with a couple different kinds of issues. And one of the issues we struggle with is how do you interpret the Constitution? And there are 2 basic ideas. There are many more, but primarily originalism, or the idea that we should interpret the Constitution as the framers meant to interpret it or intended the words, And the other is living constitutionalism, the idea that it is an evolving document with dynamic meanings that can change and adapt even when we don't formally amend it. And there are a lot of debates. You'll hear debates about that going forward, but they each have their issues. Certainly, it's legitimate. It's a little bit like exegesis of the Bible and understanding scripture to say you go back to what those words really meant at the time. Problem with that is it would disenfranchise and exclude many, many people, including women and people of color and men who don't own property. On the other hand, it's hard to find boundaries to living constitutionalism. So I think we have to understand what those ways are and then go forward. But my big question today that I wanted to talk about is who interprets the Constitution? We often think that's a job for courts, and it's true that in our landmark decision, one of the greatest Supreme Court decisions of all time, in 1803, Chief Justice John Marshall wrote for unanimous court that it is emphatically the province and duty of the judicial department to say what the law is. In other words, interpret the Constitution. But all three branches of government at the federal level and state and local officials, police officers, protesters interpret the Constitution. And so do we. Has anybody in here ever criticized a president or a senior government official? When you did that, you were implicitly interpreting the rights guaranteed by the First Amendment. Because in a lot of places in the world, yeah, it might be hard to hold on onto your head if you did that, right? So you are relying on the First Amendment when you do that, your freedom of speech. So it's kind of good to think about that when you protest something, even when you start talking in a public square. We're relying on the First Amendment, perhaps at the heart of our democracy. So we need, of course, we need lawyers. Being a lawyer, I want you all to realize that we need lawyers. I hope many of you will come here to this law school, but if you're an undergrad, but we need courts, but we also need to be constitutionally literate ourselves. And let's just talk about a few examples. How about schools? School principals, school teachers, school boards are often interpreting the Constitution. And back in 1940, in a case called Minersville versus Gobitis, a Pennsylvania school board decided that if a student wouldn't pledge allegiance and salute the flag, then that student should be forced to do so or expelled. Two little kids who were Jehovah's Witnesses believed that to do that would be to engage in idol worship. So they were first, the school tried to physically force a little boy to raise his hand. And by the way we saluted the flag back then, it was like this. Look familiar? It's a Roman centurion's salute. We got rid of that during World War II because it came to symbolize something very different with the Nazis. But at any rate, they physically lifted his hand and forced him to salute the flag. And they brought a case, and the family lost. When they lost across the country, first the kids were out of school, their parents were subject to criminal proceedings for neglect by not enrolling their kids in a school. They didn't have the position to put them in private schools. And they also lost their store because there was so much looting and vandalism. Across the country, Jehovah's Witnesses were attacked for being unpatriotic. 5 of them were killed at least, and others were really hurt because of this decision. Supreme Court got it wrong, probably, but they fixed it 3 years later in a case called West Virginia versus Barnett. But it isn't over. I'm sure some of you read about the case decided in June of this year about Brandy Levy, who was a cheerleader. She was a sophomore. She tried out to get to the varsity squad in her high school in Pennsylvania. A lot of this happens in my home state of Pennsylvania. Can't tell you why. But at any rate, she tried out for the squad and she didn't get it. So she wrote a kind of profane rule, I think appropriately in some of our views, said you can't do that if you are a cheerleader. So what happened is they threw her off the squad and they excluded her. The only thing was she was doing that outside school. So did she have a right, or could the school govern her speech even outside school? And what the Supreme Court said, no, you can't govern that. But the point I have about who should interpret, the school got that wrong. And Brandy had 4 years of her life, 25% of her existence living under the cloud and the consequences of that action. When you come to wars and protests, the Supreme Court repeatedly ducked the question of the legality and legitimacy of the Vietnam War. And then most recently in the Black Lives Matter protests, we had the clearing of Lafayette Square, the invasion of St. John's Church courtyard. The lawsuits are pending, but with respect to the protesters, they've been dismissed with respect to all the federal officers because of special doctrines that have to do with when you can sue federal officials. So we need federal and state, all government officials to understand the Constitution and apply it properly. And each of us needs to know what to do. I'm now going to turn over the podium to Professor West and just finish with saying judicial rulings can sometimes allay fears and controversies, but social media keeps all of us on our toes and can often broadcast very different messages. So learn the Constitution. I'd be happy to talk with any of you about it anytime. Thank you.
Okay, thank you. So I want to thank my colleagues, thank our audience here today for coming to this event of an interdisciplinary nature. I think in politics and law and history, we all spend a lot of time talking about the Constitution, but I find myself that some of the most stimulating conversations are when we talk to each other. So I'm glad you're here for that today. My job as the historian on the panel is to reflect on what history and the discipline of history and the historical perspective can teach us about why the Constitution matters today. And so to do that, I want to do two things. First, I want to talk about what I'm going to call the Constitution in public. That is, think here of the Constitution not as interpreted by courts, not as interpreted or applied by lawmakers or executive branch agencies, but in a more generalized sense, what people in the American public think of the Constitution and the men and women who made it. I want to think too about how politicians use the authority that attaches to the Constitution for their own political purposes. And I want to do this both because I think it helps us, again, history stuff. I want to think a little bit about the history of Constitution Day itself, the day that falls tomorrow, because I think it's connected to some of our recent public controversies over questions about, for example, the teaching of quote unquote critical race theory and over the 1619 project. So I want to touch on that, and then I want to touch on, just sort of suggestively, and we can follow up with the Q&A, a few more specific areas of the Constitution that I think matter in our public life today. And I'll try to suggest both how I think historical approaches are important in understanding those for you as an informed citizen of the Republic, but also to think how that historical approach is in some ways kind of in tension with that public understanding that I talked about a minute ago. So I would say there are probably two things that we can agree upon about Americans and their Constitution. First of all, that they revere it. And second of all, that they actually don't know that much about it. And it was to address the second part of that Senator Robert Byrd of West Virginia in 2004 pushed for legislation that made him effectively the founding father of Constitution Day. Now, Byrd, like other founding fathers, isn't actually where the story starts. The story starts in 1940 when Congress passed a resolution that created what it originally called both Citizenship Day and I Am an American Day. That observance was to take place every year in May, and the original legislation didn't actually mention the Constitution at all. Rather, it spoke in general terms of impressing on Americans the responsibilities and significance of citizenship, as the statute called it, and the form and genius of our government. 12 years later, 1952, Congress moved Citizenship Day to September 17th, the day members of the 1787 Philadelphia Convention signed the draft Constitution. Byrd built on that 1952 legislation, but he changed it in a couple of ways. First of all, he changed the name. Previously, it was Citizenship Day. Byrd changed it to Constitution and Citizenship Day. Second, he added a federal mandate. Educational institutions receiving federal funding are required to hold educational programs on or around September 17th to teach students about the Constitution. The Department of Education made clear in later guidance that you have to do it, but no specific content for those presentations is required. So we can say anything we want. Robert Byrd, however, was pretty clear about what he thought the purposes of teaching the Constitution were. Robert Byrd believed that to know the Constitution was to love the Constitution, and thus to know the Constitution better was to love the Constitution more. And this kind of language of love, the language of cherishing, this is how Robert Byrd spoke publicly, both about the Constitution and about Constitution Day. In 2005, on the first Constitution Day, he called for Americans to renew their devotion to the Constitution. He cited the 19th century politician Daniel Webster, who had referred to the Constitution as a miracle. He was using, in other words, Byrd was, a kind of quasi-religious language that resembles what sociologists and historians have called American civil religion, which involves in part treating secular figures and texts as deserving of religious adoration. The Declaration of Independence and the Constitution, in this view, become scripture, sacred texts. The authors become prophets or saints. Now, we can find echoes of this way of thinking about the Constitution in a couple of recent controversies of the last couple of years. As I said, one over the 1619 project, the New York Times project about race in American history, and the backlash to it. And second, the recent wave of state laws and regulations trying to ban the teaching of what the designers of those laws called critical race theory. Now, there are a number of legitimate objections, questions, debates to be had, for example, about the status of slavery in the Constitution, as Professor Duggin referred to. It's there, but how is it there? How much was not there? What compromises you made? We can talk about that. Certainly in the legal academy, ever since critical race theory emerged as a legal school of thought and practice decades ago, it's been debated, critiqued, but that's not what we've heard. Those kind of debates, criticism, that's not what we've heard from state legislators. It's not what we read in the 1776 report commissioned by Donald Trump. It's not what President Trump said last year in his Constitution Day declaration, when he praised, as he put it, freedom-loving Americans who rightfully venerate and defend the Constitution, and he condemned others who wish to tear down our institutions and threaten our sacred constitutional freedoms. So here's one way the Constitution matters today. Think back to our sort of title question for this panel. It matters because it's been weaponized in our culture today. Now, I don't mention Donald Trump here to sort of pull us into the vortex of partisan debate. Rather, my goal is kind of the opposite. That is to suggest that he and his imitators and his followers are following in a way of thinking about the Constitution that is not unique to them, that they did not originate. These recent controversies, toxic as they may be, reflect an approach to the Constitution that runs deep through American political culture and helped, at least in part, motivate Robert Byrd in the creation of Constitution Day. Both reflect an impulse to celebrate and venerate the Constitution. Both take the meaning of the text itself as self-evident and self-contained. Robert Byrd was famous for carrying around a pocket copy of the Constitution. He didn't try to bring along, how many volumes is the U.S. reports? He didn't try to bring along the U.S. reports and everything else that's been written about the Constitution.
Close
Right?
to 600.
600, right? You do it today with a phone, I guess. When Byrd, when some of these recent people have talked about the Constitution and the framework, it's clear they mean the document of 1787 and its authors. And we see that reflected in the date chosen to recognize Constitution Day, September 17th, the date of the signing of that original Constitution, which the statute calls the date of the formation and signing of the Constitution. Now, we don't have to get sidetracked in debates about originalism and textualism to recognize that the statute is at least badly worded, not flat out wrong, because the Constitution wasn't finished. Even if you think it's just a text, it wasn't finished on September 17th, 1787. And amended 27 times, as Professor Duggin said. Now, I want to make sure I leave time for Q&A, so I'm just going to briefly sort of signpost two more ways in which I think the Constitution matters today, and where I think a historical perspective can help us appreciate that. One is the area of voting rights, which become part of the Constitution really only in that amending process, 14th and 15th and subsequent amendments. And the second is the Electoral College, which is part of the 1787 Constitution, but a part that the framers themselves didn't think worked that well. It soon required a 12th Amendment to fix it. After that tie between Burr and Jefferson in 1800, the means of selecting the president has been a constant source over 200 plus years of complaint and controversy in American history. It's led by one historian's account to more proposals for amending the Electoral College and method of selecting the president than any other part of the Constitution of 1787. So both of these are examples of why the Constitution matters. Voting rights because of recent state attempts to restrict voting procedures. The Electoral College because of what we saw happen after the 2020 election and its after. And so both of these, just to wrap up, are examples, I think, where a historical perspective can add to the conversation. That conversation has to include the original text, the text of the 1787 Constitution, the text of the 15th Amendment, but it also has to include what came before and after. That is, how and why those texts took the form they did, afterwards, how they were applied, how they were contested in ways that led to controversy, and even as we've seen, crisis, and landed us where we are today. Now, on the one hand, what I just described there basically seems banal, it's obvious, it's civics education, right? On the other hand, I think that approach to understanding the Constitution kind of conflicts, or at least doesn't sit easily with this more static reverential approach to the document of 1787 and its framers, an approach that we see reflected in these recent controversies and that are kind of written into the DNA of Constitution Day itself. So I will stop there. We can talk more about any of that later, but now for Professor Green, politics.
Thank you, Professor West, Professor Duggin. You heard from Professor Duggin about things like how to interpret the Constitution, who interprets the Constitution, and Professor West on what history can teach us about who interprets the Constitution and how to interpret it. Since I'm a political scientist, I'm going to talk about something a little bit different, but also touch upon those two themes in my comments. The first thing I want to say is I think that the last several years in American politics has raised people's awareness of the Constitution and what it says. Certainly for me, I'll admit as a political scientist, I'm not a constitutional scholar, and there are things that came up over the course of the last several years I was not familiar with. So I think, for example, many, if not most of us, were not very familiar with the Emoluments Clause. And suddenly that became a major issue in contemporary politics. What can President Trump do with his hotel? Where do the profits go from that hotel, et cetera? So I think in some ways it's been a healthy several years to make us all more aware of the Constitution and some of the details that are in it. But I think also, to me, more important is that it has increased our awareness of certain elements of our democracy related to the Constitution that we either have taken for granted or weren't aware of. So what I want to focus on in my comments today is the importance of political norms and how important those are for the ability of the Constitution to actually work in our democracy. There's two political scientists, Julia Azari and Jenny Smith, who wrote an article back in 2012 called Unwritten Rules, in which they discussed the importance of political norms for constitutional democracies. And they used our country as an example. And they said that norms are very important because they achieve three important objectives. One is to fill gaps in existing rules and constitutional text. If you look at our Constitution, there's a lot of things it does not say. And over the last 200 years, we have often had to fill those gaps with laws. But we can't fill all the gaps. And norms play an important part in determining how we do things that the Constitution doesn't tell us about or tell us what to do. The second important role of norms is to help competing institutions work together. So we have the powers of the executive branch, the legislative branch, and the judicial branch laid out in the Constitution. Those have also been filled in with laws over time. But there's a lot that aren't set about how these institutions are supposed to work together. So for example, in the House and Senate, if they can pass similar bills that aren't the same, how do they resolve those differences? Not really clear in the Constitution. So you have to set up some practices that may be in the rules of the chamber, or they may become norms that you follow. And the third important role for these unwritten rules, as R.A. and Smith argued, is they complement existing rules by regulating behavior in a parallel fashion. So for example, you may have, say in the Senate, a rule that says it requires a supermajority to pass things. Okay? And there's no exact, and there's no previous question motion, so you can't stop debate with the majority vote. So what do? So norms are important for telling senators, okay, this is when we can filibuster things, and this is when we cannot. So it works with the existing rules of the Senate. Norms are critical for a democracy to function, as R.A. Smith argue, and they also point out we don't usually notice them until they are broken or violated in some way. And that's what I think the last several years really raised our awareness about norms, is because there were norms that were being broken or being ignored that we often took for granted. Now, a lot of that attention was about President Trump. I can't tell you how many times I saw an article that called him a norm-breaking president. It kind of got to the point that it was just hard to decide what's a norm, what, it's breaking norms all the time. What does that really mean? And that's important. But the example that I want to talk about is what happened on January 6th here in Washington, D.C. And I think what that event did, with hundreds of people going to the Capitol, breaking into the Capitol, presumably to try to change the outcome of the presidential election or to affect the counting of electoral ballots, was that it showed how so many of the things that happen in a presidential election in the transition process are based on norms, not on what the Constitution says. There's a lot of text in the Constitution about presidential elections, Article 2, Section 1, and the 12th Amendment, but there are norms. There's things that aren't there. So for example, the Constitution doesn't really say very much about what to do if there's a dispute over counting the electoral ballots in a state. And it wasn't until Congress passed the Electoral Count Act of 1887 that there was a process for determining how to deal with disputed votes in a presidential election. There's also a norm that at the state level, secretaries of state, even if they're partisan, are supposed to be neutral in how they count votes. Norms also ensure cooperation between the branches of government. So even though the president, right, is sitting in the White House and might have lost re-election, the norm is that the president stays neutral and lets the process play itself out at the state level and then in Congress, and does not try to get involved in how those ballots are counted. And then there's also a norm related to parallel written rules. So the Electoral Count Act of 1887 presumably solved problems that stemmed from the 1876 disputed election. But as Professor West was saying, there's always been disputes about the process, including this act. And what we saw in January was that there's a norm that normally members of Congress simply act neutrally. They open the ballots, they say Arkansas votes for Trump, they count them, and they're done. Even though they're partisan, even if they take a position, the norm is they don't get involved in that process. So the norm is parallel to the process that Congress follows. And what we saw on January 6th was some of these norms being violated. We saw the president and his allies, not just in the White House, but also in Congress, interestingly, getting involved and trying to intervene, in effect, in the counting of ballots at the state level. And even the vice president, we just discovered, the most recent book about the Trump White House is to be believed, was actually asking people, is there a way that I could also get involved in this process and count these ballots to help Trump? That's a violation of a norm about what the executive branch is supposed to do. And the norm about parallel operations. Now, what's interesting here is that in the last few election cycles, you have a Democrat here or there, usually Democrat voting against or petitioning, trying to get a petition to nullify the votes of a particular state, like Ohio, I think in 2004. This was unusual, but it was so minor that it kind of sort of left by the wayside. But what we had on January 6th was scores of Republicans in the House and some in the Senate actually voting against or voting to nullify or to not count the votes in Arizona and Pennsylvania. Again, it didn't pass, but it was remarkable how many were willing to do that. This was a norm-breaking event. And it indicates that perhaps in the future, members of Congress will simply vote with their party and not pay attention to particular ballots and how they're being counted. In fact, in one case, there was actually Congressman Louis Gohmert of Texas and some of his allies tried to have that law thrown out altogether in the court so that Vice President Pence could decide independently which ballots would be counted and which would not. That's really quite remarkable. So what I think this tells us, what this event, among other things, tells us is that, yes, the Constitution matters, but what really matters is whether our leaders and we ourselves, the public, are willing to follow not just the letter of the Constitution, but the principle behind it. So we have to follow and respect what the Constitution says and not merely either read it the way we want, or, as Professor West said, in many cases, we're not very familiar with the text of the Constitution. I want to just close with a quote from, paraphrasing a quote from a political scientist named Robert Dahl. He was writing about the Constitution. And many have argued that the Constitution is critical for us to be a democracy. And he wrote, actually, no, we're not a democracy because we have a Constitution. It's because we're a democratic society that we adopted the Constitution and we follow it. So we can't rely on the Constitution, his point is, to keep us a democracy. It relies on us as a people to respect not only what the Constitution says, but norms of democracy in order for the Constitution to still matter. And with that, I will close. And if there are any comments from Professor Duggin and Professor West?
Oh, I think we've been covered a lot of ground here, and I've been fascinated by hearing my colleagues, and I hope you will have some questions.
Yes. So we'll open the floor for questions or comments. Either what we've said or on the general topic of the Constitution and Constitution Day. Yes, sir.
So Professor Green, you talked a lot about like the norms and how they're broken about around the time of January 6th. And in 2024, 2028, with other presidential elections, likely to be very close and contested between Democrats and Republicans. Do you see that the norms could be either strengthened or restored by that time, or do you kind of see in the future that if a norm is broken, it just kind of almost stays broken and people just kind of discard in the future?
So I do think that a number of folks who follow the issues of norms in our democracy over the last several years, some of them, frankly, I think overstate the extent to which they're broken permanently because they're broken once. One of the reasons I kind of got tired of looking at social media is I see political scientists saying, "Oh my God, Trump just did this. It's the end of our democracy." Well, yeah, he did it once, right? That doesn't mean that it'll happen again. You can look back in history. I'm sure Professor West knows better than I do. Times when norms have been broken, but then we went back to the way they had been before.